Uh, Good afternoon, everyone. On behalf of Sathi College and Department of Law, I, Lieutenant Gaurang Rajwadkar, welcome you all for the today's session that is on Indian Companies Act 2013. Today we have with us Professor Chetan Gandhi, sir, and he will address you regarding the Indian Companies Act and all aspects of Indian companies on the topic of the Indian Companies Act 2013. This subject is basically there in the syllabus of SY second year, that is in the semester 3 and the semester 4. In the semester 3, they have Contract Act, and in semester 4, they are having the Indian Companies Act, Partnership Act, Limited Liability Partnership Act, and IPR. So today we will have this session on the Indian Companies Act 2013. First of all, I will just introduce today's speaker. Today we have with us Professor Chetan Gandhi, sir. He have completed his Masters in Arts in the Leadership Science, Company Secretary, as well as Masters in Law, Diploma in Information Technology Laws, He is also certified practitioner, as well as he is currently a leadership mentor and provides the corporate training programs in legal, secretarial, leadership, management, and various aspects of the industry as a visiting faculty guest lecturer at in the University of Mumbai. Also at international level, he provides the leadership training for the different corporates. He is also given the session to the Indian companies comprising of senior management and different companies at Amity University and various other organizations. If you see, the sir is having very vast data, and he's having a knowledge of the legal field, also technical field, as well as he's having the practice in the company laws as a company secretary. So also he is working as an academic head in Eduora Technologies Private Limited for the CACS CAT CCLAT 12th and 11th and 12th Commerce Division students. Such a great personality we have today with us. So this session will help you a lot for the getting some good knowledge regarding the Companies Act. Okay, you can explore your knowledge from this particular session. You can ask the queries at the end of the session, the question answers round. I welcome Professor Chetan Gandhi, sir, on behalf of Sathi College and Department of Law. Thank you so much, sir, for joining us. Now I will just hand over things to you so you can carry on with the session. Thank you so much, sir.
Thank you. Thank you very much, Lieutenant Gaurang, sir. This, I understand, will not be an interactive session, and we'll take up all questions and all that later on. That's what I understand. And in case any questions are there, you can definitely put up on the chat. And namaste to all of you, and thank you very much for inviting me to give a session on company law, and primarily from your syllabus perspective. And it is very interesting, in fact, to understand, and it's very important also to understand about the company's concept and all that. Even though you all are from commerce background, that's what I've been understanding. Even though a person from non-commerce background definitely should understand basic concepts, which we'll be also discussing in today's session. And starting with the Companies Act itself and company law, and talking about the company, very scratch, if we take, starting from the very scratch, if we understand any company, they are all regulated by a particular law. And accordingly, there are different laws for different forms of organization we have seen. And we have seen that there have been different sizes of organization. Like we have a sole proprietorship firm, we have partnership firm, and so on and so forth. When we want to do business at a bigger scale and wider scale, we have companies. And these companies are regulated by a specific law, which is known as Companies Act. And there have been many company laws. We have company laws from 19th century. Then we had in 20th century also. Last century, we had of 1913. And then 1940s, 1956 was the post-independence company law that we had. And after 1956, we have the latest law that we have. We in fact call it as the latest or the new law, but still it is also quite old now, and that is of 2013. So that's around 8 to 9 years old. And so first of all, we should know that which law is now applicable, and that's now is Companies Act of 2013. The first thing. Second thing is, when we see a storybook, okay, and when we read about any novel we take up, so we will see that there are different. The whole book is divided into different chapters, and then every chapter has some theme, some base on the base of which the story flows. Similar thing is there in company law also. In Companies Act, if you notice, the whole act is divided into different chapters. And when it was formed, it had 29 chapters. And now they have added one more chapter and making it as 30 chapters. And this new chapter has been added as 21A. And still, the last chapter number is 29. Since the middle chapter, a new chapter which has been added is in between. However, we have 30 chapters in the Companies Act. And in fact, whenever we are studying any law also, it's always advisable to see the basic structure of the act. And then we get a better understanding. Then if we overall see the structure, like in the storybook, in the novel, we see the novel is divided into chapters, and each chapter will be further divided into paragraphs. In this case also, the law, we have different paragraphs, and in Act, these paragraphs are given numbers and they are section numbers, and accordingly the whole Act flows in these chapters and further subdivided into section numbers, and these section numbers are serially numbered. So 1, 2, 3, 4 will be in the beginning chapters, and then if you see later chapters 300, 400 and all, they'll be in the later chapters. Now we have 30 chapters, basic structure. Initially we had 470 sections in this law. Now there are more than 520 sections. However, the last section number is 470. In between, we have seen the chapter has been added, and so also sections have been added in that particular chapter. And overall, if we calculate, there'll be more than 520 plus sections. Okay. However, first section is section 1, and the last section is section 470. This is how the structure is. Now, moving ahead. So we understood the basic concept about the act, the structure of the act. Then if we move ahead, every chapter in a story will have some or the other theme. Okay. And similar thing we have in this law also. So the very first chapter is about preliminary. We call it as preliminary. First, just lay down the preliminary ground, preliminary level. And in this preliminary, primarily we have 2 sections. First, the title, and second, definitions. One unique thing of all the Indian laws you will come across is section 1 is same in all acts, and that is title, the name of the act, where it is applicable and all. So that is common throughout, first of all. So that becomes very easy also. Section 1, title and applicability. So we know what is the name. It's Companies Act 2013, where it is applicable in India. Previously, we used to have laws stating that it is applicable in whole territory of India except the state of Jammu and Kashmir. Now, after the changes in the constitution and all, and now they being the union territory of a country and whole part of a country, even these laws are applicable to these part of the India, that is Jammu and Kashmir also. So now this law is name is the Companies Act 2013, and the whole law is applicable only in territory of India, not outside. Most important. Everything is applicable to Indian companies, and those companies which are in India, those who have set up a business in India. That's what we have to understand. Second, We understand act is there, there's a law and all. However, along with the act, we also have to read and refer rules. Now, what are these rules? Rules are nothing but they are, in simple words, the procedures which are to be carried out, the application of the act, the law. The act provides provisions, it provides this is the law. You have to do this way. Means you have to take permission. How to take permission? What form I have to file for the permission? All those things, the procedural part is provided in rules. And all chapters have, normally all chapters have corresponding rules. So if I'm talking of something about directors, they have rules regarding directors. If I'm talking something about deposits, we have rules for deposits, and so forth. So now, reading act is not sufficient. We have to read rules along with it and have a better understanding and proper application of the whole act itself. These are the basic fundamentals which we need to understand. And then let's start about the law itself. What is this law about? And I will try to simplify as much as possible, whatever, and you can definitely ask me questions also. And we will discuss the basic concepts about overall restricting to your syllabus also. And so while going through your syllabus is beautifully designed for your SYBCom majority students and all. And I'll be primarily referring to your syllabus part, and then accordingly we'll have discussions also. So primarily we need to understand what is a company. So company means a company which has been formed under this act or under any previous law. Now, what is this act? This act that we are talking to is about Companies Act 2013. There have been many companies which are there, but they have not been formed under this act. They were already there existing before 2013. For example, Reliance Industries, it was already existing. Tata Capital, it was already existing. They have been formed under the previous law. So all companies are considered, those entities are considered as companies which are formed under this Act of 2013 or any previous law. So companies like Reliance Industries, Tata Capital, they have been formed under 1956 Act. So we have to refer to, means we have referring to 1956 Act, which was an old act, but now its applicability is minimal, hardly anything. However, since they have been companies under the old act, they continue to be companies under the new act also. Company like Tata Steel, which is more than 100 years old, and it has been formed under the act of 1913, if I'm not wrong, or maybe before that. So if 1913 act, it has been formed under 1913, it is more than 100 years old. It is still a company which has been governed and regulated by the current company law, that is of 2013. This is how the laws are applicable. So whichever old companies are there, new law is applicable. Which is this new law? Companies Act 2013. First of all, so we understand the applicability. To whom it is applicable? It is applicable to all companies. Then there are a lot of advantages to have a company. And similar to that is we have specific characteristics of companies. Now, what do you understand by these characteristics? What companies have certain specific features if we see? Then they have independent corporate existence, if we take it. Now, what is this independent corporate existence? It's nothing but if I form a company, I have formed a company that is ABC Private Limited. I am the director of that company. I am carrying out this business and I have other directors also. But what happens in this case? Company has a separate legal entity, implying that company being a separate legal entity, Chetan Gandhi is different from ABC Private Limited. Even though Chetan Gandhi is the director, he's the founder, member of this company, he's a promoter of the company. So that is one of the basic characteristics that is about a different feature, different characteristics. It's a different entity, first of all. Second, limited liability. If I'm a sole proprietorship, I'm running a business, but if I do not have sufficient funds, I will have to sell off my personal assets and give it to the creditors. In case of companies, it doesn't happen like that. The member's liability is limited to the extent of his value of shares that he's holding, to the extent of the face value of the shares. So members are not supposed to pay out of their pocket, only to the extent of face value. And that's the concept of limited liability in case of the companies. Further, there is perpetual succession. It implies that companies are permanent. All directors will die. Companies will never die. All members die. Companies don't die. Tata was formed by Jamshedji Tata. He is no more. You also had J.R.D. Tata. He's also not there. But company is still going on. So directors keep on coming, going, members keep on coming, going, but company remains there. Company is formed with the help of the law, and it can be closed also with the help of the law. Entry and exit of any human beings as a member and as a director does not affect at all to form a company. Existence of the company is not affected by the presence of any person. We also saw Mr. Dhirubhai Ambani who had formed Reliance Industries. Now he is not there. His sons are taking care of it. Company is still there. And after them, Mr. Mukesh Ambani's son will be taking care of. But company will still there. Is always going to be there until and unless you close it with the help of the law. So winding up is done with the help of the act itself. And that's why we call it is permanent, perpetual existence. Further, the shares are easily transferable. You can sell the shares now. They are also in demat form. You can easily transfer shares, purchase and buy shares in case of company, which is difficult in case of partnership and all that. It has a lot of procedures, different, and you have to wind up the partnership firm and all that, which is there in case of partnership firm, but not in case of companies. And companies being legal entity, they are separate entity from companies, from members and all. They can file a case, and outsiders also can file a case against the company. Basic thing. And separate management, or I would say professional management. There's nothing but what happens in companies is now there are thousands and lakhs of members in a company. And what happens in this case is all members do not have knowledge of running the company, running the business of the company. There are few who have knowledge. So these few are appointed by the majority shareholders, owners of the company. And these few are going to act as the representatives of the company, and they will be acting as directors of the company, will be doing management of the company. So who is director? Director is none other than the person who is designated as a director is a director. Simple. And he will be taking care of the management of the company. So shareholders are at one place, directors are at one place. And directors have knowledge, and so there'll be professional management. One of the feature and one of the advantage also, which will help the growth of the company and for diversifying and overall growth of the business of the company. Why? Because they have professional management. Those who are experts will be taking care of the management of the company, and they'll be directors on the board of the company. One. Further, last but not the least, separate management and separate ownership, separate property, which means that now I am the shareholder of Reliance Industries. Okay. I cannot go to company, Reliance Industries company, and say, okay, now I'm the shareholder. I have 1,000 shares. Oh, I'm rich also. And so now in this scenario, certain table space is mine. I'm going to use this table. I'm going to use this chair and I'm going to sit every day because I'm the shareholder. I'm the owner of the company. And so I will use this table space. Can I do that? No. Who is the owner of the table space? Who is the owner of the chair? Who is the owner of that particular property? I am the owner of the company. I'm not the owner of that particular chairs and all those things, properties of the company. The assets of the company belongs to the company. I gave money to the company and company purchased whatever they wanted to purchase, land, properties, and a lot of other things. So all those things that company has purchased with my money belongs to company and does not belong to me. So that is separate ownership of property. I cannot claim ownership over the property of the assets or assets of the company. I am only the shareholder and I'm the overall owner of the company, but company owns the property. So that's about the characteristics of the company and the features you can say, or plus the advantages overall over the other forms of organization. Moving ahead, companies, if you'll notice, there are primarily three types of companies. You'll form three types of companies, whether for first one person company. That is, only one member is there. That's all. There are no more members. One person company is one member company. Maximum one, minimum one. That's all. Then another type of company that we have is private company. In case of private company, minimum 2 members, maximum 200 members. And then the third type of company that we have is public company. And these public companies are none other than, what are they? They are bigger than private companies, of course, and minimum number of members in public company will be 7. And maximum, no limit. No limits have been fixed for public limited companies. So a company can have n number of members in case of public company. So that's about the different types of companies. There are different categories of companies also. And these categories are companies limited by shares, companies limited by guarantee, and unlimited company. Limited by shares will imply that there are shares in the company, shares are distributed to the shareholder, and the liability of the shareholder is limited to the face value of the shares. Limited liability. Limited by guarantee. The founder members, those who are forming the company, they will give a guarantee. And they'll mention the guarantee in the charter documents that in case the company is closed down and company doesn't have sufficient money, they will give from their pocket to the extent of guarantee provided. And they will mention against their name the guarantee amount. That's companies limited by guarantee. That money is asked only at the time of winding up, not before that. And if money is insufficient to pay off the creditors, then only. And the last one, unlimited liability company. The name itself signifies the liability is unlimited in case of unlimited liability company. So it becomes similar like a partnership firm or a sole proprietorship firm. Then, moving ahead, who forms these companies? These companies will be formed by legal entities, people, human beings and all. So we will be forming the company. And what do we call them as? Those who are forming the company. These people who form the companies are called as promoters. Yes, they are the promoters. And if we see legal position is like they are neither the agent of the company, they are not the owners of the company, they are not the trustees of the company. They are not the owners, they are not the agents, they are not the trustees. Then who are they? They are acting in fiduciary capacity. They are having a fiduciary position. Now, what is this fiduciary position? It is like they have all these responsibilities of agency, trusteeship, ownership, but they are not going to have direct ownership. They will promote the business of the company. and they will see to it that the company is developed further, the company grows further. So they will be in such a position that they will be taking care of the company, but they are not trustees. They'll be taking care of the properties of the company, but they are not the owners of the company. And they'll be working on behalf of the company, because company is a legal entity, but it doesn't have hands and legs. Okay, you need human beings to carry out the function of the company. And so they will be working on behalf of the company, they'll be managing the company, but even though they're working on behalf of the company, they are not the agents. So this is the position of the promoters. And who are these promoters primarily? They are none other than those who are forming the company and whose names are mentioned in the annual return as per the definition. Annual return is nothing else but a return which is required to be filed every year. The way we file income tax return with IT department, same thing, we have to file annual returns giving all the details about the company every year with the regulators of the company and with the government organization, government body who is the authority over the company. And that authority is none other than registrar of companies, and the ministry that regulates the company is Ministry of Corporate Affairs. So we have to make an application and give the details about the company on the annual basis in annual return also. So any person who has been mentioned as a person who is the promoter in annual return will be considered as promoter. Any person who has been mentioned promoter in the prospectus is also promoter, and so on and so forth. In simple words, those who are forming the company are the promoters. First. Second thing, these promoters, they are liable. They're liable for incorporation of company, and in case they provide any false information, then they are liable again. They are liable for any wrong statements told to shareholders and told to general public. They are liable for any misstatements in prospectus, and if they do anything wrong for the company. I've been using this term prospectus now and then. What is this prospectus? Prospectus is nothing but a document which, if you take admission in college, the college gives a prospectus giving all the details about the college, library facilities, the courses which are run in the college, and so on and so forth. Similarly, prospectus is nothing but all the information about the company right from its inception, right from the date of its birth till date. What has happened? What is the capital? Who are the shareholders? Who are the directors? And what is the business being done? Everything, the financials, all details are there in the prospectus. So the directors, the promoters, when they want money from general public. General public will not just give money looking at the face of promoters. They have to get some information about the company. So the document in which all information about the company will be, that is provided to the Janta public to get money, is nothing but prospectus. And the names of promoters also mentioned in the prospectus. So that's about the promoters. Further, promoters, before formation of company, they'll be entering into contracts on behalf of the company. So is company into existence? No. Before incorporation, a company is not into existence at all and accordingly has no capacity to contract. Consequently, nobody can contract as agent on its behalf, because an act which cannot be done by the principal himself, it cannot be done by an agent also. So the promoters will enter into contract, and these contracts are called as pre-incorporation contracts. What is this incorporation word? It's nothing but, in simple language, formation. Pre-formation, before formation, contracts are entered by the promoters on behalf of the company, on behalf of the proposed company which is being formed. And once the company is formed, all these transactions are required to be ratified. Once these transactions are ratified, approved by the company, once it comes into existence, then it is accepted as a contract and it is accepted as a liability to be fulfilled by the company. So any pre-incorporation contracts, any pre-formation agreements, okay, are there, it cannot be enforced by anyone. It should be first approved by the company once it gets formed, when it gets its legal entity, and then it can move ahead. So that's about pre-incorporation contracts, which we have, which will be entered before the formation of the company for the benefit of the company. Then we have about corporate will. Now, what is will? If we see, will is nothing but a parda, a curtain. Okay, so we have this concept of will, which is being enjoyed by all companies. Corporate will, we call it. Now, what is this parda? Do they also have parda? Do they put a parda? Okay, no, nothing like that. But there is a concept which is being considered as a corporate will is, now, for example, I just take a company like Tata Group company, TCS, okay, or Tata Steel. Who are the directors in that company? Who are the shareholders of the company? Who are the owners of the company? We always tell, it's a Tata Group company. So it's the owners are Tata. Okay. And but directors, can you, if we don't know the owners, okay, and you just see the directors, is there any director in Tata Steel from Tata family? No, there is no Tata family member as a director on the board. Who is, then we need to see, then how, then can you still tell that's a Tata Group company? Because then we check who is the owner of this company, who are the shareholders of the company. And there we see, oh, majority is being held by so-and-so group, that is Tata Group and all. And then you can say, okay, then this is a Tata Group company because majority shares are held by them. So if any companies are there, if any company is there, from just the name, you may not come to know who are the directors, who are the owners of the company. So we have to lift the corporate wheel. And then you see, when you lift the wheel, see when the wheel is there, when the parda is there, gungat is there, you cannot know who is the person behind that particular gungat. When you lift it, you come to know, oh, this is the person. That's the person who is behind that wheel. And so also, when you further study about any company and check, oh, these are the shareholders. Oh, these are the directors. They are taking care of the management of the company. Then it is said as you have lifted the wheel and you check out who are the shareholders. Now, why do we check this? Why do we lift the wheel? Actually, there's no wheel, but still we call it as a lifting of wheel. In short, it's nothing but checking the ownership of the company. Who is the ultimate owner of the company? That is what we check out. In short, we can also consider it as an inspection we carry out, investigation we carry out. Who is the real owner? I'll just help you with an illustration. What happened was, I've been running a company and it's a very good company and it is selling medical equipments to different hospitals. Okay. Now what has happened? These medical equipments are being sold and I have a certain set of customers. I had one marketing person. Okay. He was heading marketing and he resigned. He left the job. So I told him, okay, you're leaving the job, fine, but you better do not approach my clients. Do not approach my clients. Me also. You should not carry on business in this particular radius of 5 kilometers where my office and my business is. You carry out business at other place. So what did my marketing head do? He left the company, he left the job, and he agreed, yes, I will not carry out business over here and I'll not approach your clients. Then he formed Jupiter Limited company. His name is Mr. X. He forms a company, Jupiter Limited. And then what I observed, since 2-3 months, my customers are getting diverted. I'm losing my customers. And where are they going? They are going to Jupiter Limited. Now they're becoming customers of Jupiter Limited. So I was a little surprised. Jupiter, I just saw the name. Oh, I didn't come to know who is the owner of the Jupiter company. Must be someone, maybe a foreign company or what. I didn't know. But then I started observing, oh, many of my clients have gone away to this Jupiter Limited. So then I check out, who is this Jupiter Limited? Let me lift the corporate wheel. And then when I left it, I checked, who is the director? So director was my marketing head's family members, his wife and other family members. So that also I didn't come to know who is the director. Okay. Then I checked, who is a member of this company? And I saw 90% shares are held by Mr. X. When I lifted the corporate wheel, when I pierced through the corporate wheel, when I did the investigation, and I did the inspection and investigation, who is the owner? And then I found out the owner is none other than Mr. X, who was my employee, marketing head, and he is only soliciting all my customers. Is it allowed? No, it is not. Because he's agreed. He cannot approach my customers and take away my clients. So what I did while carrying out this investigation about who is the actual director, who is the shareholder, who is the owner of the company, what I've done nothing else but lifted the corporate wheel of Jupiter Limited and checked out and saw, oh, Mr. X, my previous marketing head himself is the shareholder of this company. And so he is taking away my clients. I will file a case and he has to pay penalty. This is what the concept of lifting of corporate wheel is. Then we form a company. And when the company is being formed, like when you took admission in college, what you must have given certain documents, birth certificate, Aadhaar card details, Aadhaar photocopy, your latest passing results, whichever exams you passed, and so all you are degree college students. So your 12th mark sheet and FI BCom, all those mark sheets you must have submitted to the college and got the admission. Correct. These documents like birth certificate, Aadhaar card, they are very, very important documents for you. If you do not have them, your mark sheets you don't have, then you cannot get admissions without these documents. Same thing is in case of companies. There are 2 important documents in the company. And if these documents are not there, then company is not there. And these 2 important documents are Memorandum of Association and Articles of Association. These 2 are also known as charter documents. So what is this memorandum and what are these articles? Memorandum of Association is nothing but it's a document which has certain information, basic information about the company. And it is divided into certain clauses. Now, what are these clauses? So if we notice, I'll help you with this illustration. You have gone in a remote place in a jungle, okay? And nobody's there, and you are going with your friend, and you are there in the jungle, and suddenly you hear a small baby crying. You hear a child's cry. So you immediately look out and you see a very small baby is crying. Oh, the baby is crying. You immediately check out, is somebody there? The parent of the baby? Nobody's there. So you take the baby and you shout, anybody's there? This baby belongs to whom? No reply. So you then decide, okay, nobody's taking care of the baby. And out of compassion, you decide, okay, let me take care of this baby. Now, very first thing what we will do is, even when, especially girls, when they used to get dolls and all that, whenever they get new dolls, they are always accepted. And very first thing what you do, you give a name to the baby. You give a name to your doll. You give a name. And that's what. So you decide, I will give a name to this small baby. And that's name clause in the memorandum, which has the name of the company. Then you decide, where will this baby stay? They will stay with me. Okay. Or so they'll stay at my home or at some orphan house or in hostel. Where will this baby stay? So where this baby is going to locate, stay, is nothing but where the company is going to be there. Where is the office of company going to be there? And that's the registered office company. And that is registered clause. Second clause, first we saw the name clause. Second is the registered office clause. The third, now you decide, now when the baby is growing up, see, every child, every parent has some dreams about the child. Ultimately, child will do whatever they wish to do, but you will think over, the baby may become a lawyer or may become a big businessman, or you start educating the child depending on what the child wants to become. And you will decide, you will be thinking about, should the baby become a professional chartered accountant or a doctor or some other profession? You dream about it and you start working on it. So you decide and you work out, what is the baby going to be in future? What is the object of this company that I'm forming? Why I'm forming the company? So company doing something. The baby may become an army person, army personnel, working in the defense, saving the country, working for the country. Okay, that's the object of that particular baby, of that particular person who is getting who is being groomed up by you. Same thing. Once a company is formed, the company is formed for what purpose? So company is formed for a certain particular purpose, and that's nothing else but the object clause. The third clause is the object clause. You decide what is the company going to do. After that, post that, now you will decide, if I want to make this child a doctor, I may have to spend around 1 crore rupees. If the person has to be a chartered accountant, 2-3 lakhs will be sufficient. And so forth, depending on what the child, for child's upbringing, you will need money. So you'll decide how much money is required. And that's the capital clause. That's the authorized capital clause in case of company, the fourth clause. That is, you decide during the lifetime of the company how much money I need. And that's the capital clause, the fourth one. Then, if anything is done by this particular child, the liability falls on you. If they do very good in studies, see, you are the caretaker, you are taking care of, now this is your baby, you get that appreciation. And if they do wrong, you are liable for the wrongs done by this child. The way you are liable for the wrongs done by the child, the next fifth clause is liability clause. And liability clause states about whether the company is limited by shares, limited by guarantee, or an unlimited company. And then you decide, who are going to take care of this baby? Is it myself alone? Then I'll form one-person company. I and my friend, we both will take care of this small baby. We'll form a private company. I and my whole family, everybody in the family member, all 7 of us will take care of this baby. We are forming a public company. And these people who are going to take care of, I take them in writing. I take their affidavit in writing. I take a confirmation in writing. You're going to take care of the baby, huh? So I take the confirmation in writing, and that's what is, I take confirmation of the first shareholders in writing that they are going to take how many shares of the company and how many shares they are going to subscribe at the formation of the company. And accordingly, the sixth clause is subscription clause. That's about subscription. That is, who are going to be subscribers to this memorandum of association. So that's the charter document memorandum divided into 6 clauses. Then we have another important document, that's articles of association. Articles of association is nothing but it deals with the internal management of the company. So internal rules and regulations of the company will be provided in articles, and you already know what is provided in memorandum of association. That is name clause, registered office clause, object clause, authorized capital clause, liability clause, and subscription clause. So that's about the important charter document, which is required to be filed when we are forming the company. It is to be filed with the company, with the registrar of companies. So company will file with ROC and carry out its activities. So that's about the charter documents that we have. Then, in this company law, when we are applying company law, there are three important doctrines, and these doctrines are none other than the doctrine of ultra-vires, doctrine of constructive notice, doctrine of indoor management. Now, what is this doctrine? Doctrine, in simple words, we can say it's nothing but principles, certain principles to run this company, to run any corporate organization. And this is one of the principles. What is this principle? Doctrine of ultra-vires. Now, what is ultra-vires? Ultra-vires means something which is beyond powers. If, for example, you are supposed, your mom gives you money, pocket money, and you are given a pocket money of 1,000 rupees per month. You have to spend your money within this 1,000. You cannot spend more. You didn't have any authority to borrow money from anyone and spend it all. But you borrowed money. You borrowed money from your friends, and now you have spent 1,500. This is beyond your authority. You are not supposed to do that. This activity which is beyond the authority, which is not legal, is ultra-vires. So companies have their own authority, and this authority is fixed by the object clause. They can do only particular object, what is mentioned in the object clause, the business that will be carried out. Now, if the company has a business of hospitals, then they'll have hospitals and they'll have patients. Now, they cannot say hospitals not doing very well. Now I'm interested in chocolate making. So now I'll have chocolates. You cannot do. You cannot make chocolates, manufacture chocolates because you like chocolates making. To do that, you will have to change the object clause. Then you can do it. Take permission of shareholders, follow all the regulatory requirements, and then you can change the object clause. But now, if the object clause of your company is to carry out hospital business, you cannot manufacture chocolates. So that's the objective of the company, and anything done beyond the powers of the company is nothing but ultra-vires. So if something is done by the company which is not stated in memorandum as the objects or powers is prohibited by the doctrine of ultra-vires. So can the company do? No, because it's an ultra-vires act, and any act which is ultra-vires is void. Void means illegal. It has no legal sanctity. It cannot be enforced. You cannot bind the company to carry out all those activities which are ultra-vires. So that's about doctrine of ultra-vires. Then we have doctrine of constructive notice. Now, doctrine of constructive notice, and we also have doctrine of indoor management. Now, doctrine of constructive notice implies that on registration, the memorandum and articles, what happens when you're registering the company and you have to file all these documents with registrar of companies. These documents, memorandum and articles, are public documents. They are open and accessible to everyone in Janta public. Yes. And therefore, every outsider who is dealing with the company is deemed to have notice of the contents of these memorandum and articles of association. And it is implied that people know about it. So it is assumed that any person dealing with a company is aware about the contents of these documents, and that's what is known as doctrine of constructive notice of memorandum and articles. So every person dealing or proposing to enter into contract with the company is assumed to have constructive notice of the contents, and so then he cannot say, oh, I didn't know that this is there in the memorandum. It is assumed you should know. what are the powers of the company and what are the clauses in the memorandum and articles. So that's about doctrine of constructive notice, where the company is protected and outsider are not protected, because outsiders are considered that they should know everything about the company through memorandum and articles. So if memorandum mentions something, it is implied they are aware of. You cannot say, oh, I never read it. You never read it, so it's your problem, boss. Doctrine of constructive notice, company is not going to be liable. And then we have doctrine of indoor management, which is opposite of it. Over here, outsider is protected and not the company people. So in case of doctrine of indoor management, what happens is it is implied. Now there are certain internal rules and regulations. So it is implied and understood and assumed that whatever internal procedure is required to be followed, it has been followed. And accordingly, company is taking action. So now I am the managing director of the company, ABC Limited, and I come and enter into contract with you, and I say on behalf of ABC Limited, I'll sign the agreement. Now, I being the managing director, and it is assumed, managing director have powers to sign a simple contract and all that. So it is assumed and it is implied that your internal formalities are all taken care of. Now, as per the internal formalities, now since this contract is for purchase of land, which is more than 10 crore rupees that I'm purchasing from you, and any transaction more than 10 crores, I have to take board approval. So board permission is also required. So it is indoor management. It is an internal requirement. Outsider person need not go through internal approval liya kya. They need not ask that way. So what will happen? They can assume all the internal procedures are taken care of. All the internal procedures are complied with. And that's what is doctrine of indoor management. If they are not taken board approval, and managing director, as a managing director, I've signed the agreements. Now later on, I cannot say, oh, I didn't have the approval. I never had any permission of the company. So this agreement is void. No, that cannot happen. The company is liable and bound by the activities that I carry out as a managing director. And that's the doctrine of indoor management. So we have gone through these three doctrines also of ultra vires, something beyond memorandum and articles of association, doctrine of constructive notice, where the company is protected and outsiders are supposed to know what are the contents of memorandum, and doctrine of indoor management, where the outsider is protected and he can assume the internal procedures are taken care of by the company. So that's about doctrine of indoor management, doctrines that we have. Apart from that, I had discussed something about prospectus, and let's understand about the prospectus. Now, prospectus is a document which I've already shared with you and explained you, is nothing but a document which will be given to the Janta public, the prospective investors, to what? To invite subscription to shares, to get money. So we will show the Janta public the prospectus, a document giving all information about the company. And once we give all information, then the prospective investors will go through the document and see, oh, this is the information about the company. Oh, company is doing very good financials. Company is doing very good profits and all that. Okay, I will invest in the company. And so that decision will take after going through the prospectus. So that's about the prospectus. Then there are different types of prospectus also. That is, we have prospectus like red herring prospectus, shelf prospectus, and all. So let me explain them in brief. A brief concept about this red herring prospectus and shelf prospectus. So first, shelf prospectus. Shelf prospectus, in this case, what will happen is the company needs money. And for example, I'm setting up a hospital and I need around 1,000 crore rupees to set up a hospital. Do I need rupees 1,000 on day one? No, I don't need total 1,000 on day one. But yes, I will need it gradually. So what company will do? They will file a detailed prospectus with registrar of companies. They'll file with ROC a detailed document, which is a shelf prospectus. And then whenever they need money, they will raise money, and they need not raise full 1,000 crore rupees. They will ask for money in tranches. in installments, you can say. So what will happen now? Company has filed a detailed prospectus in January 2022. Now, in February, I need money. Company needs money. How much? Around 300 crores to purchase land, property, and give orders for the construction of the hospital and all those things are there. So I need around 300 crores. Okay. So now it is done in Feb. Today is 26th Feb. So it's almost 2 months are over. So whatever changes have happened in 2 months, only that information I will provide in those 2 pages or 3 pages. That is known as information memorandum and submitted to the company. Submitted to the registrar of companies and get money. So then I'll make an issue of 300 crores. And once I get money, I purchase land and I start get the construction going on and all those things are done. After that, I need more money. So it's month of June 22 and I need more money. Now, building construction is done, everything is done. Now I need to get latest modern equipments and all. And many things I'm going to get from foreign countries also, modern equipments for conducting operations and all that at the hospital. So what I'll do, I will get all these equipments, but only on the basis of money. I don't have money. I have exhausted those 300 crores. Now I want more 300 crores. So what I will do, I will again go, now from Feb to June, whatever changes have happened in the financials and anything, any new things are there, I'll provide all that information, changes that have happened, file it with the ROC, that is information memorandum, and get 300 crores from Janta Public. Get the 300 crores, use it for modern equipments and all that, and then done. So 600 crores over. Now everything is done. Now I need people, I need human beings, I need doctors and a lot of people to carry out the work. And so by August, I need 200 crores more. 600 I've already collected, now 200 crores more. So, and I start employing people and a lot of other things I'm doing. So 200 crores also spent. And then I start my business and all that. No, still I can get 200 crores because I've collected 332 in different tranches I've collected. And so still 200 crores I can collect. By what time I should collect? I should collect within 1 year. The validity of shelf prospectus is 1 year. So the validity is 1 year from Jan to December, 1 year validity. So by December, I should collect 200 crores. If I don't collect 200 crores, then, and I go in Jan or maybe next year, Feb, I want money, 200 crores. I do again file a detailed document, detailed prospectus. Why? Because the life of the previous shelf prospectus is over. So I can collect money during the lifetime that is within 1 year of filing of shelf prospectus. So that's about shelf prospectus. Then we have another form of prospectus that is RHP, we call it, or we also call it as red herring prospectus. In this case, what happens is I need certain money that I need 2,000 crore rupees. But I file the detailed document about the company's information all that with ROC. But I don't mention I'm going to sell shares. I'm going to give shares at what price. Neither I'm going to mention how many shares I'm going to give to the Janta Public. So everything is finalized. I need 2,000 crores, but I don't know what price I'm going to fix. So what I do, I file it with the ROC, draft red herring prospectus, we call it as, and then I will check out. What I'll check out? How much people are ready to pay. So I will do a market survey. And on the basis of my research, I decide, okay, on the basis of research, I think company can get 1,000 premium on 10 rupees shares. So I will charge 1,010 rupees and take 1,000 as premium. People are ready to pay me so much on the basis of my market survey. And so then I fix. The shares are sold at 1,010. 10 rupees of face value and 1,000 is a premium, securities premium. Oh, so now I know 2,000 crores I'll get on the basis of distribution of shares at the price of 1,010 rupees. And accordingly, that details of what price I'm selling it off, how many shares I'm giving, all those details are decided, and final prospectus is filed with the company, with the registrar of companies. So this is like RHP was there, and then the final document comes up as prospectus. Then, so that's about prospectus. Then we have the concept of membership. Who can be members? Any person can be member who has a legal entity can be member, and he can acquire membership by subscription. That is, he purchases the first shares of the company. A person can be member by purchasing shares from other shareholders. Okay, and so forth. So either they can purchase from the market or from another shareholder privately and all that, and accordingly membership can be acquired. Membership can also be acquired through transmission. My father was holding shares, now he is no more. His shares comes to me since I'm his son. I get his property, I get his shares. So it also a person can become shareholder through transmission also. And if I am the shareholder and I appoint somebody as a trustee to my shares, caretaker to my shares, so the person will be trustee to my shares, and he doesn't become a member, but he becomes a trustee. So these are the ways a person will be holding shares in different forms. Then further, we have the concepts of directors. Most important, the one who manages the company. Who takes care of the company? Who manages the company? None other than directors. And that's what we have. Now, directors. What is directors? Directors are none other than those who have been designated as directors as per the Companies Act. And these directors will be taking care of the management, overall management of the company. Now, before that, when we saw about the prospectus, there's also a concept of private placement where I don't go to Janta public, I just go to few people and get money. Because when I go to Janta public, it's very expensive. And I give a prospectus to all people, it's very, very expensive. So what happens in case of private placement? I just approach certain people, explain about my company and induce them to invest in my company. And that's what is private placement. So in private placement, I approach them, they give me money, I give them shares. It's all privately done. I don't file prospectus with ROCM. Okay, as I do in case of the public issue. So, but there's a restriction. In public issue, I can give to thousands of shareholders. In case of private placement, at a time, I can give to 50 people. And in a year, I can give to maximum 200 people. That's what the requirement is in case of a private placement. And then who will be doing all this, taking decisions that whether we want to go for private placement or public issue and all those things? Of course, the directors. Now, directors will be carrying out all these activities and doing out the management of the company. Now, we have different forms, types of directors also. Different kinds of directors have come up. And plus, there are certain qualifications and disqualifications also provided in the company law with respect to directors. So now let's understand about directors. So do you want to be directors? Is there anyone who wants to be directors? And I would definitely assume that yes, all of them would love to be directors on the board of a company. Yes. So to be a director, the person should have one number. And which is his number? Director's identification number. To be Indian citizen, which number you need to have? To be Indian citizen, you need to have Aadhaar card number, isn't it? To be director, you need to have DIN number, that is director's identification number, which is compulsory. You make an application to Registrar of Companies or Ministry of Corporate Affairs and get a DIN number. And this DIN number is unique for every person. And a person can have only one DIN number, cannot have more than one. For example, can I have more than two PAN cards? No, I can have only one PAN number. I cannot have two PAN cards. Same thing, I cannot have more than one Aadhaar card number, more than one PAN number. I cannot have more than one DIN number. So person can have only one DIN number. First of all, to be director, I need to have DIN number. And then there are different concepts of directors, different types of directors also. One of the concept of directors which has been introduced in this new law of 2013 is independent directors. Yes, independent directors are those who cannot be influenced. You cannot influence those people while taking decisions and all that. And they are totally independent. They are not the family members of the directors, relatives. They are not the family members of the promoters. They are totally independent. They are outsiders. So these are the independent directors. And primarily, if you notice, directors are of two types: executive directors, non-executive directors. Executive directors are those directors who are giving their full time to the company and they are working fully for the company itself. Like we have Mr. Mukesh Ambani. He is the executive director of Reliance Industries because he's giving his full time to the company. He's managing the overall affairs of the company and he is the executive director. His wife, Mrs. Nita Ambani, even she is the director on the board of Reliance Industries and she is not executive director, she is non-executive director. Why? Because she is coming to the company for board meetings and only certain times when her services are required. Else, she is not there on the board. She is not there coming to the company for regular basis or like on daily basis. She has her own assignments and she is doing her own work. Mr. Mukesh Ambani comes to office every day and works for the company every day. Mrs. Nita Ambani, she does not come to office every day and she does not work for the company every day. So that's same family members. Husband is executive director. Wife, she comes for the companies during meetings and for some other work only. Only sometimes she comes. So she is non-executive directors. And in non-executive directors, there'll be also few independent directors, are totally outsiders. Like, for example, if we appoint Mr. Anil Ambani on the board of the company, then he is the brother of Mr. Mukesh Ambani, who is the managing director. So he cannot be independent director. He is a family member only, the younger brother. But if somebody else joins, then, for example, we have Mrs. Arundhati she was ex-MD of State Bank of India. Now she has joined as an independent director on the board of Reliance Industries, not related to any of the family members or relatives and all that. And she is an independent person, independent director. One thing. Second thing we have is the concept of women director. First time introduced in the company law that all companies must have women director. And this concept has been introduced on the basis of all listed companies compulsory and in case of all public limited companies, if their paid up capital is more than 100 crores or if the turnover is more than 300 crores, you need to have women director. Yes. And apart from companies are regulated by company law, companies are also regulated by a lot of other allied laws and SEBI laws and all that. For example, they are also governed by SEBI LODR regulations, listing obligations and disclosure requirements. So these regulations are also there. And as per these regulations, top 1000 listed companies must have one independent woman director. So independent woman director is like we have Mrs. Arundhati on the board of Reliance Industries as an independent woman director, and Mrs. Nita Ambani, she is a woman director on Reliance board, but she's not independent. She's a family member of the promoters. That way, it makes a difference between independent and non-independent. But every listed company must have in women directors, and every listed companies which are top 1000 listed companies must have independent women directors. So this is, along with companies, if you have to read some other laws also, allied laws, we can say, which are applicable to companies. Then we have a concept of additional director. This additional director is a concept of director where if during the year, normally who will appoint directors? The members of the company. So members, when do they meet? They meet at the annual general meeting. But if I want this director to be appointed before the next annual general meeting, I cannot wait. Now today is February. My next annual general meeting will be in the month of August. I cannot wait so long. I want to appoint that person immediately. So that person will be appointed immediately by the board of directors, and he holds that position till the next annual general meeting. So that person is considered as an additional director. Then we have concept of alternate director. I'm going out of India for around 6 months for my further research studies. I'm going outside India. So I'm going to stay outside India for more than 3 months, and I'm on the board of this company, ABC Limited. So what I'll do, in my place, Mr. A will come and attend the meeting. So that is, he will be serving the company in my place, and that is alternate director. He's alternate to me. That's the alternate director concept that we have. And then we also have nominee directors. They are the representatives of the financial institutions, banks, and all institutions, public financial institutions, who are providing money to the company, or even government. If government is holding shares, and then there'll be representatives or the nominees of the government or any financial institutions on the board of the company, and through nominee, the shareholders, the original shareholders, will check out everything is going fine, no, all things are done properly, no, because there's some control from the external director, that is the nominee director of the company. Okay, so that's about directors that we have. Then we have and we have also seen these directors also, if we see, they are the agents, they are the trustees, they are the owners, but they overall, they are not the employees of the company, but they'll be working for the company. They are not the trustees of the company, but they are going to take care of the company. And they are definitely, apart from trustees and employees, they again act as a fiduciary capacity. So they will be working for the benefit of the company, is what will imply in fiduciary capacity. That is, whatever decisions are taken by the company, by the directors for the company, will be ultimately for the benefit of the company and not for any other purpose. Ultimately, the main goal of directors' decisions are for the benefit of the company, even though they are not the trustees, they are not the owners of the company, and they are neither the employees of the company, they are neither the agents of the company. Yes, they are not the agents of the company, but they'll be working on behalf of the company. This is how director's position is also, again, in fiduciary capacity. And then let's understand about meetings. Now, what are these meetings for? Meetings are primarily for to come to certain decisions. And people cannot just, I want to decide, and so I just take the decision. No. They have to meet. And so directors will be meeting each other, and they'll be meeting, all directors will come together, discuss about the company's growth, future prospects, and come to certain decisions. That's about meeting of directors. And so every quarter they must meet, and the gap between two meetings should not be more than 120 days. That's what it is. Plus, directors will be meeting. If they're meeting, there should be a particular minimum number of members present at the meeting, minimum number of directors required for a valid meeting. And the minimum number of members required for a valid meeting is also known as quorum. So quorum for the meeting is nothing but minimum numbers required. So in case of directors meeting, 1/3 will be considered as the minimum number of members required for a valid meeting. So 1/3 members should be present for directors meeting. And of that, minimum 2 members must be disinterested in any of the resolutions which are passed. Disinterested means they are not interested in the resolution. They are not interested in the decision making. Further. So that's about the board meetings. We have shareholders meetings also. And shareholders meetings will be, one meeting is held every year, and that is annual general meeting. It is to be held once in a year. And in this meeting should be held in the same city, town, village where the registered office of the company is situated. It should be held during business hours, and it should not be held during national holidays. It can be held on Sunday, but not on national holiday. National holiday implies 2nd October, 26th January, 15th August, okay, and 1st May. You cannot have meetings, shareholders meetings on these days, but you can have meetings on Sundays so that shareholders can come and attend the meeting. And it should be during working hours of the company. So between 9 to 6. You can start meeting at 5:45, which may get over at 9 o'clock chalega. But you should start between 9 to 6 during working hours of the company. That's about annual general meeting. Now I need to take certain approvals of shareholders on urgent basis. In that case, I cannot wait till August, September when I'll have my annual general meeting. In that case, I will call shareholders meeting, but that is for extra purpose, extra meeting of shareholders, and that is known as extraordinary general meeting. So extraordinary general meeting is nothing but a shareholders meeting between two annual general meetings is extraordinary general meeting. That's about shareholders meeting. And we can also have meetings of certain class of shareholders, certain class of people who are the shareholders of the company. If certain decisions are required to be taken for preference shareholders, example, then you will call only preference shareholders meetings, class meeting. Or if you are taking decisions for certain creditors, then creditors meeting. So that's class meeting is there in case of meetings. And so that's about the meetings that we have. And about directors, one more concept is now we also have the concept of qualifications of directors, which has been provided in the rules of the company rules. And we also have disqualifications, that in case if a director is disqualified, if he is fulfilling certain criteria, then he will be disqualified. And what are these qualifications and disqualifications? In short, a person to be director, he must have certain skills either in finance, law, management, sales, marketing, administration, research, corporate governance, or any other aspect. A person has qualifications, a person can be appointed as independent director. And a person who cannot be appointed as director, then few of them cannot be appointed as director. Those who are of unsound mind, their mind is not working, they are mad, they are mentally incapable to take proper decisions, who are discharged, who are undischarged insolvent, who are insolvent, who have compromised with their creditors, they have not paid money to their creditors, cannot be considered for directorship. Those who have been convicted for offense involving moral turpitude, they have committed some heinous crime, for example, murder, and the person has been jailed for more than 6 months, for not less than 6 months, the person has been jailed, and he has come out of the jail and 5 years have not yet lapsed, then the person cannot be qualified as a director. And if a person is jailed for 7 years, he cannot be director in any of the company for the lifetime. If any person has been in jail for 7 years or more, cannot be considered as a director in future. Further, if court passes an order or any tribunal passes an order that so-and-so person should not be appointed as a director, then is disqualified to be appointed as director. Or in case a director is there, he's holding shares of the company, he's a shareholder of the company, but he has not paid money on those shares, he has not paid the call money, and it's been more than 6 months, the person cannot continue as the director of the company, and such person cannot be director of the company. And such many other disqualifications are there. So just giving you a brief illustrations about different disqualifications of directors. And that's all from my end. So it's exactly 1:26. And so now any questions from your end, you please ask. So we can you can mention in chat, or you can please ask me the questions, or how it is to be taken, sir. Gaurang sir, you please take it forward. How do we take questions? Sure. So any questions from any of the participants, please ask. So that's all from my end. I've tried to minimize all different concepts. I've tried to cover all concepts that you have in your syllabus, and also minimized with brief, I would say, I've touched all those topics so that you get an overall idea, and hope so it has been useful for you. And now questions from your end.
Good afternoon, sir.
Good afternoon.
My question is, what are the changes in the the Indian Companies Act 2013 with respect to the Indian Companies Act 1956?
Many changes. Many changes are there. For example, I'll there are many, so I cannot take all, but I'll take few. For example, we have the concept of independent director, first time brought up in Companies Act. We have the concept of women directors, and you yourself are a woman. You have all the opportunity now to be on the board of the company. So concept of women director has been introduced for the first time in this Companies Act. Then one person company. Previously, we just had private company, public company. Now we have a concept of one person company. So even one member company can be there. One person can start a company with the limited liability concept. Else one person means only a sole proprietorship. But now we can have a company. Then there is a concept of rotation of auditors. Previously, we didn't have this concept. So one auditor used to be there for ages and ages. But now we have a concept of rotation of directors, so auditors. So auditor can be there for 5 years at a time. And in case of a firm, then they can be there for 2 consecutive period of 5 years. Then there has to be a cooling period of further 5 years. So there's the concept of rotation of auditors, and such many new other concepts have been also introduced in the Companies Act, and they've been very beneficial. And you also have differential voting right shares, again, which has been there in the Companies Act. And one more thing, which I did not share at the board meeting time. Now we can have board meeting, not only physical board meetings, that is everybody comes in the under one roof and have discussions. We also have the concept of e-meetings. So video conferencing and audio-visual means of meetings are also all allowed and valid. And in fact, with this COVID scenario, we have all experienced also all these meetings being conducted electronically. So there have been plethora of changes, and these are the few changes which I would love to highlight on in this limited time that we have. Any
Okay,
other?
sir, thank you.
Welcome.
Good afternoon, sir.
Good afternoon.
My question for today is, what is preferable, a LLP or a company?
Depends on the type of business and the size of the business. And considering both the concepts have limited liability concept. In fact, LLP have the benefits of partnership also and the company. Okay. As a company, if you're a big size business, there are a lot of compliances required to be done in case of company. Whereas the compliances in case of LLPs are limited compared to company, if we see. And other way, if we see, then companies, if we have, then apart from perpetual succession and all that, companies have higher tax burden compared to LLPs. So if we see from tax rate, but overall, the credibility of an entity, if we see, if I go for a credit facilities to the company or to the bank, to a financial institution, and I present myself as a company, I have more credibility than any other entity, because company has more standing for any credit facilities compared to any other entity. Because if it's a LLP, like a limited liability partnership firm, we always go, oh, limited partnership firm. Ultimately, it is not that, the life of that partnership firm is not that long compared to the company. So considering many other factors, I would suggest when your business is small, you can have LLP. And when you want to grow up, and when you want more number of members, and when you want to have more funds infused and make it bigger scale organization, then definitely company will be better that way.
Okay, sir. Thank you, sir.
Welcome.
Good afternoon, sir.
Good afternoon.
My question is, if one has to start company, which documents are required?
To start a company, we need basically, first of all, we need the approval of the name. Okay, so we make an application to get the name approval. Then once the name is approved, we will need memorandum of association and articles of association. These are the basic 2 charter documents. Then we'll need certain declarations to be given by the directors or the first promoters or first shareholders of the company, that all the provisions are being properly complied with. So directors of the company will be giving all this declaration. Then we need declaration from the professionals like practicing chartered accountant, cost accountant, or a practicing company secretary. They'll be giving declarations, certain declarations. So all those things will be filed with the registrar of companies. And once we file these basic documents, that is declarations and memorandum and articles, and get the name approved, and we can accordingly get the certificate of incorporation from the company, from the registrar of companies. So these are the basic documents which are required to file for formation of company. And along with that, yes, we'll also need to file information about the directors. So director's consent is required to be filed, and the form, that is DIR 12, is required to be filed with the registrar of companies. Plus, I need to give information about the registered office of the company. So I will also have to file form INC 22 with the registrar of companies, giving details about the registered office of the company. And subscription clause is always already there in the memorandum, where I've provided the details about the first shareholders of the company and how many shares they are going to give. And once all these documents are given, I get the certificate of incorporation for formation of the company. I cannot still start the company until and unless I give a declaration with the registrar of companies within 6 months of formation of the company, that all the monies that were subscribed, the subscription money has been all received by the company, and then they can even commence the business. So this, right from incorporation and commencement, all these documents will be required. That's all for the formation of the company and for commencement of the business of the company.
Okay, sir. Thank you, sir.
My pleasure. Any other questions?
So I will just check the YouTube.
You're not audible, sir.
So I was just checking the YouTube, so there are no queries on the YouTube.
Okay.
Yeah, so we can conclude the session now, sir.
Fine.
Yeah. Okay, sir.
Thank you.
Yeah. Thank you so much, sir. So the very wonderful session it was. You have touched all the aspects of the Indian Companies Act, and from almost you have covered all the aspects from all the two modules, from the starting from the how to start the company, what are the major and the basic aspects of the company. So I hope it will help our students to brighten their knowledge, whatever we have completed, whatever syllabus we have completed. So it will help them a lot, and it will enlighten them and encourage them to start their own companies. I hope they will surely will go into the business, and it will help them. Moving to the end of the session, I, Lieutenant Gaurang Rajbhatkar, will express my vote of thanks to Professor Chetan Gandhi sir, to giving his valuable time and express his views on the topic of the Indian Companies Act 2013. It will surely help our students for their semester examination as well as in their future tenure. Also, I'm very much thankful to Dr. Madhav Rajwade sir, Principal Sathe College, for their valuable guidance and giving this opportunity to encourage to arrange this wonderful session. I'm also thankful to Pramodini Sawant Madam and Dr. D.M. Nerkar sir, Vice Principal and IQAC Coordinator of the Sathe College, for their constant support. I'm also thankful to the Vinod Gaware sir, Assistant Principal Junior College, and the supervisors of the Junior College, that is Shri Kisan sir and Shri Anjali Sawant Mad, for their extended support. And once again, I'm very much thankful to all the audience, the students, for being there and for being an enthusiastic audience. And if you have any queries, so I have just posted the link in the chat box for the feedback. So you will be getting the e-certificate of the same, and you can just, if you have any query regarding the session, and if you have some suggestions regarding the same, So you are most welcome. You can just fill the feedback form. It is available on the YouTube as well as on the Zoom. I have just pasted the link, so you can just fill the form, and you will be getting the e-certificate of the same on your provided email addresses. So kindly put the proper email address over there, so you will receive the certificate. Thank you so much, and everyone, and thank you so much, sir, for being there and giving us your precious time. Thank you so much. Thank you. So I here with the principal, with the permission of the principal, I declare that today's session is over. Thank you so much.